Welcome. Today we're diving into something literally every law student and legal buff obsesses over at some point: the principles and categories of civil damages. If you've ever found yourself wondering how on earth the legal system takes abstract suffering or a ruined car and translates that into a specific dollar amount, well, you are in exactly the right place. We're going to unpack the exact, highly structured doctrines that make this whole complex process work.
Okay, so here's our roadmap for this explainer. First, the core principles of damages. Second, the 6 kinds of damages. Third, compensation in case of death. And finally, we'll wrap up with the injured party's duty.
Let's jump right in. Section 1. The core principles of damages. Restoring the balance. So, at the absolute core of civil damages is this fundamental Latin principle, restitutio in integrum. Now, what does that actually mean for us? It means that the injured party should be restored as closely as humanly possible to their original condition before the wrong even happened. The law's ultimate goal here isn't to give you a massive windfall or make you rich. Nope. It's simply trying to put you back exactly where you started. It's about fixing the balance. Now, this is super fascinating. The law actually rigorously separates 3 words that we normally just toss around interchangeably in everyday life: injury, damage, and damages. Look at this. An injury is the illegal invasion of your legal right. It's the wrongful act itself. Damage, without the S, well, that's the resulting loss, the actual hurt or harm from that injury. And damages, plural, is the pecuniary recompense. It's the actual cash awarded to compensate for that damage. It's like this precise 3-step chain reaction.
All right, moving on to Section 2, the 6 kinds of damages, the MENTAL arsenal.
To easily memorize the specific tools the court has in its arsenal, we use this super handy acronym, MENTL. That stands for moral, exemplary, nominal, temperate, actual, and liquidated damages. Let's break these down one by one to see how they actually play out in the real world.
We're going to start a little out of order with A for actual, which is also known as compensatory damages. This perfectly shows how actual damages are neatly split into 2 completely distinct buckets under the law. On the left, you've got daño emergente. This is your actual, tangible, physical loss. Think immediate out-of-pocket stuff like hospital bills or fixing a wrecked car. Then on the right, you have lucro cessante, which is your unrealized profit. Basically, it covers the money you failed to earn, like the wages you entirely missed out on because you were stuck recovering.
But listen, here is a massive catch. Courts, they do not play guessing games. The absolute, undeniable requisite for actual damages is that they must be duly proved with a reasonable degree of certainty. You've got to bring the receipts. Literally. You need receipts, competent documentary evidence, concrete numbers. Without undeniable proof, you're not getting that money back. Next up in our acronym is M for moral damages. These are meant to compensate for the invisible harms, right? Mental anguish, physical suffering, wounded feelings, but you definitely don't just get them automatically. You have to strictly meet these 4 demanding legal hurdles. Number 1, a clearly sustained physical, mental, or psychological injury. Number 2, a factually established culpable act or omission. 3, that wrongful act absolutely must be the proximate cause of your injury. And 4, it has to be based on specific cases enumerated by law, like evident bad faith or gross negligence. It's a really high bar.
Then we've got N for nominal damages. Sometimes, no physical money is actually lost. So nominal damages step in simply to officially recognize that your legal right was invaded. They're adjudicated purely to vindicate or recognize a right of the plaintiff that the defendant violated. It's really not about indemnifying you for a financial loss. It's more like the court officially saying on the record, hey, you were right and your rights were breached.
Stepping up slightly for nominal, we find T for temperate or moderate damages. These are awarded when we absolutely know you lost money. Some pecuniary loss has clearly been suffered, but because of the messy nature of the case, we just can't prove the exact dollar amount. Imagine you clearly lost earning capacity, but say your exact business records were destroyed in a fire. The court acknowledges the financial loss, but steps in to grant a moderate, reasonable amount, simply because exact certainty is impossible.
All right, now for L, liquidated damages. What makes these so unique is that the 2 parties already agreed on the financial penalty in their contract long before any rule was ever broken. They are literally agreed upon to be paid in case of a breach. And the courts? They will strictly enforce this pre-agreed number unless they find it to be shockingly unconscionable or directly against public policy. Finally, we reach E for exemplary or corrective damages. Now, these are fundamentally different from the rest. They're imposed by way of example or correction for the public good. Basically, they're tacked on top of your other compensation as a severe public warning. To get these, the offender's act must be accompanied by bad faith, malice, or gross negligence. It's the legal system's way of making a huge example out of the offender so nobody else even thinks about trying it.
Let's shift gears. Section 3, Compensation in Case of Death, Quantifying the Incalculable.
The moment a death is legally proven to be caused by a defendant, a baseline civil indemnity is automatically awarded. Current jurisprudence fixes this automatic baseline at 50,000 pesos for standard cases, and it actually scales up to 75,000 or even 100,000 if the crime is accompanied by qualifying circumstances or if it's considered heinous.
But to move beyond that automatic baseline, we have to look at the Villa-Ray transit formula. This is wild. It's a fascinating mathematical attempt by the Supreme Court to calculate the deceased's exact lost earning capacity. Net earning capacity equals 2/3 times 80 minus the age of the victim at death, all multiplied by their gross annual income minus living expenses. It's this rigid, highly standardized formula designed to project exactly what the victim would have financially contributed over their entire expected lifetime.
But wait, what if you can't prove the victim's exact grocery bills or their rent? Well, if the exact living expenses cannot be proven by solid evidence, jurisprudence elegantly pegs it right down the middle at 50% of their gross annual income. Half is just assumed to be living expenses, and the other half becomes the net income used for that formula we just talked about.
Now, beyond the cold hard math of lost wages, the law also mandates additional death damages. This includes financial support for the victim's dependents for a period not exceeding 5 years. Plus, moral damages are specifically awardable to the spouse, legitimate and illegitimate descendants and ascendants. This is to help compensate for the intense mental anguish caused by such a tragic loss.
And finally, Section 4, the injured party's duty, the plot twist.
This brings us to a super surprising legal reality. What happens if the victim actually makes their own injury worse? It's a completely vital question. Let's say you're injured. Does the law just let you sit back, kick your feet up, and let the damages pile up entirely at the defendant's expense?
Absolutely not. Enter the doctrine of mitigation of damages. This doctrine demands that you legally must act like a responsible, good father of a family to keep your losses as low as possible after an incident happens. Think about it. If your roof gets damaged by a neighbor's negligence, you can't just leave a gaping hole open to the rain, let it ruin out your expensive furniture, and then expect them to pay for the furniture too. No way. You have a strict legal duty to mitigate the damage.
So what's the actual effect of a failure to mitigate? Well, if you fail to take reasonable steps to prevent further damage, the court will absolutely refuse to make the defendant pay for your inaction. You can definitely still recover for that initial damage, but any compounding, additional damage that resulted from your own lack of care, that falls entirely on you.
Which brings us to a really profound closing thought. Does true justice lie solely in the financial compensation awarded by the court, or equally in the victim's own responsibility to heal and mitigate harm? The legal framework of damages, as we've seen, isn't just about aggressively demanding money. It's about restoring a delicate balance, requiring rigorous proof, and enforcing a mutual duty of care. Keep that in mind the next time you think about the legal concept of being made whole. Thanks so much for joining me on this explainer, and keep learning.